Hi, I'm Kevin Stowie from the San Antonio personal injury law firm of Stowie and Mayo. One of the areas of law that is not very well understood by most people is medical malpractice or medical negligence. I'd like to take a couple of minutes and provide you with some basic information about the practice of medical malpractice law here in Texas. If you are curious and want or need more information about the topic of medical malpractice after you've watched this video, there are articles as well as other videos on our firm's website that you may want to check out. Also, you can always call our law firm. This video is just a basic overview. In order to know what medical malpractice is, we have to first understand a little bit of history. I need to start by saying that medical malpractice law, as provided by the Texas legislature and the Texas courts, is generally extremely unfair for victims of medical malpractice. And this fact makes medical malpractice cases very challenging for any attorney who seeks to hold a medical provider responsible for negligently causing injury or death to a patient. Powerful medical and insurance lobbyists have had a profound effect on how the law is written in Texas and how it has been interpreted by appellate courts across the state during the past 20 years. In fact, some of the most drastic, cruel, and inhumane laws in the field of medical malpractice in the entire United States were put into place right here in Texas back in 2003. In 2003, Texas Governor Rick Perry and his powerful political allies went around the state and basically lied to Texans about a fictional medical malpractice crisis in order to get citizens to favor sweeping changes in medical malpractice law. All of these changes went against the little guy and those who are killed or badly injured as a result of malpractice. The big lie that was spread was that Texans needed to save their doctors. This campaign also tried to arouse fear by claiming that there wouldn't be enough doctors for Texas unless these malpractice laws were radically changed. It was ridiculous from the start, but this campaign actually worked, and it resulted in a political payoff. Law changes that dealt a cruel blow to badly injured victims of medical malpractice, and it made the rich and powerful even more rich and powerful. The simple fact is that today, more than ever, many people all across Texas who are victims of medical malpractice will never have the opportunity to hold the wrongdoer accountable or receive any compensation or relief for the wrong that was committed. Despite the unfair system we presently have, a small number of people who are victims of medical malpractice can still bring a medical malpractice lawsuit. Now that we know a little bit about the context and the hostile political environment for victims of medical negligence, let's take a look at the process we use to determine who has a viable medical malpractice case and a reasonable potential for a successful outcome that might be worth pursuing in this unfortunate climate. We'll quickly start by saying that if you seek to bring a medical malpractice case in today's Texas courts, you must have first suffered severe consequences of the negligence in order to make it worthwhile. What is severe, you ask? Well, every case is going to be different, but in general, I interpret severe to mean death, permanent injury, permanent disability, loss of sight, a brain injury that has lasting consequences, loss of the use of a limb or limbs, amputation, paralysis, blindness, etc. In other words, we are talking major consequences here. It is just too expensive and time-consuming to bring a medical malpractice case for a mistake that had little or no negative consequences, even where the mistake itself is obvious. Once we have an inquiry at our law firm that involves severe consequences, we focus on the details and the chronology. And as a preliminary matter, it is important to recognize that a bad outcome or a bad result in medical care is inevitable sometimes. And just because an outcome for a patient is not good, this fact alone does not imply or suggest that a doctor or other medical provider has been negligent. In order to understand what really happened in a given case, we must obtain as much of the chronology or timeline and as many of the details from the patient or loved one who contacts our firm. The more details, the better. If, after getting the details and chronology, there still might be a case that can be pursued, we will order all copies of all important medical records. We will review these records carefully, and we will also sometimes have to have these records reviewed by one or more medical experts just to determine if we have a case. These experts are people who specialize in specific areas of medicine that are applicable to the case. If a case survives all of these steps, the real war is just getting started. A lawsuit will be filed against all potentially responsible or responsible parties. We will cover medical malpractice lawsuits and the discovery process in litigation of medical malpractice cases in separate videos. Thank you for watching this video, and I hope you found it informative and useful.